agreement that the council was going to discuss with the appellants. Before we get on to that, over the lunch break, I did have a look at the legal agreements I've got. I don't appear to have a full copy of the legal agreement. Does anybody have a full copy? I'm relying on what's provided in the appellant's appendices.
Of the original.
That's my understanding, yeah. Sorry, yes. Dated 4th of November 1992. I can take it in hard copy if the appellant's happy with that. Yes, it's just that final page that I'm missing, I think, from the. Does the appellant have a full copy of the?
Yeah. The signature page.
Is it just the signature page that's missing? I think there's another page as well. In fact, there's a few pages missing, I think.
2, I think.
1, 2, 3, 4. 1, 2, 3, 4, 5. So I've got 6 pages here in the copy that the council's given me, including the plan, and there's 4 pages, including the plan and the appellant's appendices. Do you want to have a look at that to check that that's? If you just for completeness, if you could just confirm before I accept it, please. Thank you.
Yeah, I think so.
Great, thank you.
Thank you, sir.
And secondly, something that I also checked over the lunch break. I'm not entirely sure that there is an appeal to modify the legal agreement. There's no separate appeal form, and that's what had confused me, but it is included in the section 73 appeal form. Now, my understanding is that it has to be in a separate process. It can't piggyback the section 73, so to speak, but I'm not entirely clear on that. I don't know if you have anything you want to say on that. I've proceeded on the basis that there is an appeal and that I've got that, and I think we can carry on discussing anything else that I need to. So I don't think there's going to be any problem that I can deal with it. It's a matter I can deal with in my decision. But is there anything you'd like to say on that as to whether there is a valid appeal against the modification of the legal agreement?
So yes, the modification is mentioned in the appeal form, section 106. It's an appeal against the decision. I accept that the regulations specify that a separate form may be used in respect of a section 106A application. But in this case, there is no prejudice to any party by the process that's been pursued by the appellant. And we're in slightly unusual territory in the condition tracking the section 106 requirement that's sought to be removed. It would have been duplicative to use 2 forms. So you'd have effectively the same application with the same documentation being made on a different form. But no parties lost out. Members of the public haven't lost the ability to comment. All the documents are before you. In the event you didn't determine the section 106 part of the application, one suspects we'd be having exactly the same argument sometime down the line.
And does the council have any comments on it as to whether there's a valid appeal against the modification of the legal agreement?
Well, we were confused as to whether it was an actual a request to modify the appeal against the modification.
Did you determine an application to modify the legal agreement? Did the council determine a specific application?
Yes.
The modification of the 106 was included on the application form, on the section 73 application form. It was referred to on that. And I think in our view, we felt we were considering that aspect. Whether or not that is absolutely the correct procedure, I think you've already discussed with the other side, but we certainly felt we were considering the modification of that agreement at the time.
Okay, thank you. And does anybody want to say anything on this? Does anybody feel that they may have been prejudiced if a valid appeal hasn't been made under to modify the section 106?
I'm just very unclear as to why the deed of variation was presented to me to revoke the entire 106 if we were only considering section 2B.
Yes, well, that's something that's not for me to comment on. That's something I think between you and the appellant separately. Is there anything else you'd like to say on that before we move on?
So merely that I've turned up the committee report and it makes express reference to the section 106 obligation serving a useful purpose, which is the relevant test to consider the removal of a section 106.
Which paragraph does it have?
It's
number?
shot through in the committee report, but it's for example, it's the officer's recommendation at 1.1. It's at 2.2.
It's okay. There's no need to.
Sorry,
carry on.
yes, sorry. Sir. Oh yes, so perhaps the best reference then is paragraph 7.1.23, which is headed removal of clause 2B of the section 106 agreement.
Okay, thank you. Well, as I said, this is a matter. I'll deal with this in my decision either way. But the council mentioned that there was a new legal agreement that was being put forward. Did you discuss that with the appellant over the break? And would you like to outline what that is?
I outlined the nature of the discussion that we had.
Yes, please do.
Yeah, so as I said before lunch, we provided the appellant with a draft section 106 agreement in the event that a new permission resulted from you granting a section 73 permission, which looked to secure both the ongoing restriction on the subdivision of the land and also a new version of the occupancy condition that was included within the original section 106. We hadn't had any comment back on that, and I think it's fair to say my discussion with the other side at lunchtime indicated that they weren't minded to enter into it.
Okay. Is there anything the appellant wants to say on that?
So yeah, a few comments. We don't think there's any need for a section 106 agreement for the following reasons. I won't repeat the submissions that I've already made about why the condition should be removed entirely. You have our position on that. If that's the case, then the only thing that the section 106 agreement would concern would be severability of the land. And we don't consider that there's any good reason to include that provision in a section 106 agreement. The reason that such provision was probably included in the previous 92 permission was because residential occupancy was tied to use of the adjacent land, i.e. that parcel of land that was going to be used as a livery yard. Whereas in either world here, in a world where you vary the condition to have some agricultural use, then that wouldn't require tying residency to a particular parcel of land. And obviously, if you remove the occupancy condition altogether, then there is no relationship between the dwelling and the adjacent land.
Yes, thank you.
Is there anything else on that?
Is there anything anyone else wants to say before we move on to conditions then? Yes,
So I've been sitting here listening to what the appellant has said, and they're saying that basically we're just a spoiling tactic to buy the land. That actually isn't true. We have got the money in place, and surely the only way to go forward is to put it up for sale, and then things can be sorted.
This
It
is
just
refer-
seems that's a bit of a sort of slight
this is
on our.
referring to what we discussed before lunch
Yeah,
about
just-
whether the
just-
property should be marketed. or-
Yeah, I think because, and they're saying that we haven't got the
It was-
money, we've
yes.
got no experience. But there are members of our family who have got experience with horses. So we just think that should actually be put up for sale. And then you determine there's probably other people as well who would be interested.
Yes, okay, well, as I said, I need to give the appellant every opportunity to have
Yeah,
final
yes,
comments
fine,
on
yeah.
any points made, so I'll go back to them on this, but is there anything else anybody wants to say before we move on to conditions then? Okay, yes, sorry, did you want to come back to
Conscious that my learned friend's been chatting and may want to make a further comment before I move on to another topic.
Was there anything else you wanted to say?
I think we did discuss briefly the merit of that requirement not to sever the land remaining. I think our view has been that it would be beneficial to retain it. I think we're of the view that, or we had been of the view to this stage, that the application doesn't relate to the removal of that clause from the original legal agreement. So the assumption was that it was remaining. But it now appears from the appellant's side that they don't feel like that it should form part of any ongoing legal agreement. I think there are some considerations to be made as to whether or not it's appropriate to allow the severing of the land in terms of potential future use under an agricultural occupancy condition, in terms of horticulture or whatever else that might require land to be associated with it. And whilst there was no objection from our environmental health team to the separate livery use and use of the dwelling, there are potentially agricultural uses of that wider site which might impact on the amenity of an unrelated occupant of the dwelling. So I think our suggestion would be that that would continue to serve a useful purpose, but obviously it's up to you, sir, to decide whether that's something that needs to continue. And I would just restate that if permission is granted under Section 73, that wouldn't be something that would then be covered by the previous agreement in our view, which was why we.
Sorry, what wouldn't be covered by the legal agreement?
Well, there is no clause within the existing legal agreement to bind it over to any future permission granted under Section 73. And that it would essentially fall away if permission was granted under Section 73. And therefore that would then just ultimately allow the severing of the site. So that if that's something that you're minded is necessary, the only way we see that being achieved is through a new legal agreement, which is one of the reasons that we had proposed one and provided it to the appellant.
Yes, thank you. Just one moment. I just want to read this part of the legal agreement, clause C. Yes, referring to severance, it doesn't refer to any changes of use of the other part of the land, does it? So I think because you were talking about if the stables were used for any other purpose, such as you use the example of an agricultural use, that may harm the living conditions of people in the dwelling. Is that what you were saying? And the legal agreement doesn't have any control over that?
No, but it would be the assumption, I suppose, that it would be that the dwelling would be occupied by the same people carrying out the agricultural use of the wider site, because it hadn't been severed, and therefore, if you allow it to be severed, you potentially have occupants of that unit of the dwelling which are unrelated to the people operating the balance of the site,
Yes.
and therefore greater amenity harm could result from potential uses of that site,
Yes.
including those which could be carried out
And your
without needing
concern is
permission.
primarily severance of the site as set out in subsection C of the
2C, yeah.
2C of the legal agreement, which the appellant doesn't seek to vary or remove. Is that right?
Well, we say that if there's a forthcoming section 106 agreement, what we say, when you're considering whether to include a forthcoming section 106 agreement, you shouldn't do one at all, because the only thing that it could include would effectively be this severance provision, and we don't need one for the reasons that I've already explained.
Yes.
And it's a slightly difficult position to accept from the council, having them already accepted the severance of the land by granting permission subdivision of the site in 2017, I think it was, when there was a very specific occupancy condition there. So it's obviously not a prominent consideration at the forefront of their minds. There is no reason to tie the land to the dwelling in the same way as there was when the livery yard was going to be attached to this dwelling in 1992, when this issue was first raised. Is the long and short of it.
Okay, thank you. Moving on to item 4 on the agenda then, to look at the conditions. So as I said, if I allow the appeal in appeal A, then what I would be doing would be granting a new planning permission to stand alongside the original planning permission. So I need to look at what conditions might be appropriate to attach to that if I do end up in that position. Does everybody have a copy of the original planning permission in front of them? That might be the easiest way to go through the numbered conditions. The first condition relates to the reserved matters. Does everybody agree that is there no need for those details to be required? Does that condition already satisfy?
Yes.
Thank you. And the same with
Oh, I get it. Yeah, of course. Yes.
and the same with condition 2, which relates to the commencement of developments. Does everybody agree that those 2 conditions are now redundant?
Yes.
And conditions 3, 4 and 5 all relate to planting and landscaping. They don't require approved details to be retained. So is there any need for those conditions or different versions of them to be
No.
attached? Does anybody have any alternative views on that? Condition 6 states the permanent space to be reserved for the on-site for A parking should be provided before the use commences and thereafter maintained. Would it be appropriate for that to be reworded to refer to the existing parking spaces to be retained?
Yes. Yes.
Yes, no objection to that.
Is there any preferred wording that anyone wants to put forward, or happy to leave me to words to that effect?
Perhaps parking and turning.
Does the appellant have any concerns with that parking
No.
and turning? And these are as existing, there's a turning area existing, is there? So for those to be retained.
Yes, that's my understanding.
Condition 7. Now I know that there's disputes relating to drainage. This condition says no development shall take place until details of surface water drainage and foul drainage for the site have been submitted to and approved by the local planning authority. The drainage work shall be constructed in accordance with the approved plans. The condition doesn't require any particular drainage issues details to be retained. So is there any need for this condition to be put back on?
No.
And does anybody have any comments on that? Condition 8 essentially removes permitted development rights for any oil storage tank, specifying how I'll read this out for clarity. Notwithstanding the provisions of the Town and Country Planning General Development Order 1988, any oil storage tank should be sited on an impervious basin surrounded by oil-tight bunded walls with a capacity of 110% of the storage tank to enclose all fill-in, draw-in and overflow pipes. Is a condition required to remove permitted development rights for the installation of any storage tank, oil
No.
storage tank? No? Does anybody have any comments on that? And condition 9 states the proposed septic tank and associated soakaway system must be sited at least 10 metres from any watercourse and 50 metres from any well or borehole. Does this need to be reworded so that it refers to any future septic tank and soakaways, or is it not needed at all?
We don't think it's needed.
Neither do we.
Does anybody else have any comments? And condition 11 requires development to be carried out in accordance with the approved plans, and as development's already complete, is there any need for that condition?
No.
Are there any other conditions that may be needed to make the developments acceptable?
Sorry.
Sorry, sir, could you just give us a second? Is that right?
Yes.
Could we just ask if there's going to be an opportunity to comment on the wording of the potential widening of the condition or alternative condition separately to this?
Potential wording, if I substitute the condition for an
Yes.
alternative, maybe, yes, it would be a good time to revisit that, actually. Are there any comments on the wording that was put forward in the pre-hearing notes?
Yes, there is from us.
Just bear with me one moment, please. So the wording that I drew people's attention to in the pre-hearing note was a model condition. I'll read it out for the benefit of everybody. The occupation of the dwelling shall be limited to a person solely or mainly working or last working in the locality in agriculture, horticulture, forestry, stud and or other rural activities, or a widow or widower or surviving civil partner of such a person, and to any residents' dependents. What comments would you have on that possible
Just
condition?
on the and or other rural activities, we think that that's potentially not precise enough because it doesn't state what those activities are. We think that perhaps it should say stud and livery or livery yard to be a bit more specific.
Stud and or livery yard instead of other rural activities.
Yeah.
If I were to go down the route of substituting the condition for that model condition, and instead of other rural activities, you put the word livery yard, phrase livery yard, what would the appellant's comments be on that?
I think so, from our point of view, if the word, I mean, we are satisfied with the condition as you've suggested, and we make that clear to start with, that our position would be other rural activities is acceptable. But if you wanted to look further into that, then I would suggest that perhaps equine use
Instead of specifically livery yard,
instead of specifically livery yard.
would equine use not be precise enough?
Sorry, sir. There's potential for that to then simply allow market occupation of that dwelling by someone who owns horses, I would say. So I think we would want a bit more precision around that. Our suggestion for including livery was simply that that is the authorised use of the land at the moment, and so it makes sense to have that specifically named in there. Our concern about rural activities was, I suppose, what is a rural activity, and in terms of, you know, the need for precision, just felt that excluding that might be helpful going forward. I think if the other side would like more equine uses named, then I think we're open to that. I think equine use generally might be a bit broad.
If I was to be going down the route of substituting the condition for this, though, then that would be allowing anybody to occupy the dwelling who complies with that, who doesn't necessarily work on the site. And it may be the case that they simply have horses rather than run it as a livery yard. Would that not be, if I'm understanding your concerns, are your concerns not against a material change of use of that adjacent land rather than someone complying with the occupancy condition?
My concern around equine use as a phrase is that it is a de facto market dwelling for someone who owns a horse. And the point of this restriction is to limit it to people involved in agriculture, horticulture, forestry, those types of uses as a special, effectively as a special need case for that type of accommodation. And I don't think equine use, I mean, if it were commercial equine use, potentially.
I think that's
Well, that's it.
it.
So, yeah.
There's a person solely or mainly working or last working in equine use.
Oh, I see what you mean, sir. May I just read
Yes,
that
yes.
before I comment on that? Sorry. Thank you for that opportunity. Yeah, I think on reflection, that probably would satisfy us. Sorry, I hadn't considered. I'd just been thinking purely about the use as opposed to the preceding employment in. So yes.
And may I just add to that, obviously Mr. Hutchinson's comments as to the potential variation to the condition are without prejudice to our principal
Yes,
case.
absolutely.
The
Yes.
plan-led approach is that
Yes.
it should be removed entirely, and it would be inconsistent with the position of the adjacent properties for there to be any condition whatsoever.
Yes, all of these discussions about conditions are without prejudice to
Yes.
anybody's case. Yes. Does anybody have any comments on the wording of that substitute condition were I to go down that route? And then are there no other conditions that the council might suggest?
No, nothing else.
Any other comments anybody wants to make on conditions?
Sir, could I just raise a point, please? I understand that conditions should generally be worded in the negative rather than in a positive, because obviously we can't make people occupy a dwelling. So would it be better to have it phrased, although it means the same, that the dwelling shall not be occupied by anybody other than, and then the rest of the wording of the condition?
This is the yes, the model condition. Well, it is negatively worded in saying that the occupation should be limited to a person solely or mainly working. You're saying that you would suggest that it says the dwelling shall not be occupied by anyone other than. Okay, does the appellant
I
have
think
any
it's okay
comments?
as it is.
But- Okay, thank you. Item 5 on the agenda is any other planning matters. Are there any other matters that anybody wants to discuss today before I move on to make arrangements for a site visit and wrap up?
Yes, please, sir. Just one matter that condition 4 of the reserve matters application is a repeat condition of condition 10 of the outline. So just procedurally that that may also need to be dealt with after, depending on the outcome.
Yes, it's quite odd, isn't it, for that to be repeated on there. That's something
The requirements in there 3 times.
that for.
Condition of the outline, condition of the reserve matters, part of the section 106.
But it is something that falls outside of what I can deal
Yes.
with in this
Yes, exactly.
appeal, and that's a matter, yes, for the appellant to address afterwards. Does the appellant want to say anything more on that?
So no, one would have thought in practice how it would work would be that your approach to the to this section 73 application would be a good guide to the parties as to how to approach the matter in future. It may be that condition 4, it was a condition 4. It may be that in practice it actually remains there undisturbed, and that we all just agree that the section 73 applies. Nothing is done about condition 4, but that's a matter for us
Yes.
to deal with in the future.
Yes. Any other planning matters that anybody wants to discuss? Okay. Well, moving on to arrangements for the site visit then. It's 2:30. I think I'd like half an hour to be able to pack up and get to the site. Is it realistic to expect a 15-minute drive from here to the site? If I'm lucky, well, that's it. Is it rush hour? Is now a bad time? I'm relying on Google Maps, 15 minutes.
No, I think that is, yeah, 15 to 20 minutes.
Well, it's 32 minutes past 2. So maybe if we were to say 10 past 3 to allow plenty of time, is that going to be a convenient time?
Yeah.
Okay, so we'll meet at site at 10 past 3.
Just to check, so we're all able to park on.
Well,
on site
this is what I
themselves?
was going to come on to. First of all, are there any health and safety issues that I need to be aware of on site? It's muddy. Are there any live animals on the site? And what are the parking arrangements? Is there parking on site? So there's parking available on site. Who is going to be attending for the appellants? And who for the council?
It'll be me and Rachel Mackenzie.
And as I said at the beginning of today, the purpose of the site visit is for me to see the site and its surroundings. I'm not going to engage in any discussions. I don't want to hear any representations. If people start making representations, I'll walk away. I'll ask you to stop. So that's how the site visit will proceed. At this point, are there any issues in particular that anyone wants me to look at or note on the site? I don't think there's any need for me to enter the house. Does anybody disagree? And yes, the members of the public at the back, as I said, it's privately owned land. The appellant hasn't given permission for anybody else to enter the site. You've heard how I'm going to conduct the site visit. Is there anything you want me in particular to have a look at on the site?
Just the unrestricted development on the land.
I'll walk around the whole of the site. As far as I'm aware, there's no outstanding documents that I'm due to receive, is there? Okay, well, thank you everybody for your contributions today. we've completed the discussion. I'll close the hearing here before attending the site visit. And as I said, no discussions on site. I do repeat that to make it very clear. Thank you, everyone.